Hello and welcome to this mini course IP Strategy 101 for SMEs and startups. My name is Maria Boicova-Wynants, an IP lawyer and IP strategy consultant in love with IP since 2004. In the upcoming lectures, I will unpack IP and IP strategy in simple terms, without legalese, and in total under 100 minutes. This lecture series is available in audio and video format. Video format contains easy to follow visuals, so if you're listening to this as a podcast, head to my YouTube channel for a video version. This is lecture number 1, Introduction to Intellectual Property. Ready? Let's go. So what exactly is intellectual property and why should it matter to you, especially if you're just starting out on your entrepreneurial journey? The aim of this mini course is to demystify the basics of intellectual property as such, IP strategy in particular, and most importantly, to share some practical advice on how to use it all to your advantage. My aim is to give you the foundations so that you're equipped to ask the right questions. After all, as they say, the right question often holds 80% of the answer. So let's dive right in. Intellectual property. Intellectual property is a bit of a legal jigsaw puzzle, which includes everything from groundbreaking inventions to the latest chart topping hit. Yes, it's not only about technology or brands, but also about a whole lot in between. Very simple, IP protects the fruits of human creativity and of human innovation, offering a framework to nurture and reward these flashes of brilliance. There are 5 main types of IP. Let me go over them quickly first. So, first, patents. Think of patents as a golden ticket for inventors, granting them exclusive rights to their brain children for a limited time, typically for up to 20 years. When we talk about patents, it's about inventions, technical solutions, not merely something new that you came up with. And no, you cannot patent your name. For that, you need a trademark. Brands are more than just logos or slogans, they're promises. Trademarks help seal that promise, distinguishing your goods and services from those of the competitions. Important to note that if you haven't registered your trademark, it's not yours, not your property, not your asset. And while a company name can give you some sort of very limited protection, only a registered trademark is the right foundation for your strong brand, for your strong asset. Copyright. Have you ever penned a catchy tune or painted a masterpiece? Copyrights safeguard your original works, ensuring you reap the rewards of your artistic endeavors. But not only that, also your software frequently falls under copyright protection, as well as any other results of your creative efforts, be it the way you envision a store layout or an internal employee manual. Trade secrets. Ever wonder what makes a company truly unique? Often it's the secret sauce, the confidential tidbits that give them a competitive edge. Trade secrets keep those gems under lock and key. But trade secrets are not just any confidential information you might have. There are conditions and requirements attached. I will discuss all of them later in the course. Industrial designs. From sleek product packaging to user friendly interfaces, industrial designs protect the aesthetic elements that make your creations stand out in a crowded marketplace. Aside from the IP instruments I talked about, there are of course also geographical indications, database rights, plant variety rights. In other words, intellectual property right universe can be fairly broad. Now, here's the kicker, as they say. IP isn't just legal jargon, it's a business powerhouse. What do I mean with it? Well, more than often, IP is viewed as a cost. However, it will only become a cost if done wrong from the very beginning. Otherwise, IP can be an important investment in an asset that can be very, very valuable for you along the way. In our today's digital age, where ones and zeros hold as much value as bricks and mortar, intangible assets like IP, they reign supreme. Understanding and harnessing the power of your IP can mean the difference between obscurity and market domination. What's important to understand right from the very start is that properly dealing with IP is not limited to obtaining formal registrations. Think of your IP right as toolkit with different uses. You can choose to exclude others from using your IP completely, or you might decide to license, to sell, or to share certain rights while retaining others. The strategy you pick will depend on your goals, on your business goals, and on your circumstances, and it will evolve as your business evolves. You might be wondering why sometimes the word IP is used and other times it is IP rights. Is it the same thing? No, it's not. Moreover, understanding the distinction between intellectual property and intellectual property rights is paramount. Try looking at IP as a treasure map. It holds only the promise of potential reaches. But the real game changer lies in securing those intellectual property rights, making them yours. Sometimes it's done by means of registration, sometimes by means of certain steps you need to make or simply avoid making. Hence, the first thing to remember, intellectual property is not the same as intellectual property rights. When there are rights established, intellectual property becomes truly yours. In the cutthroat world of business, securing IP rights, it's akin to fortifying your defenses. Without them, your bargaining power diminishes, leaving you susceptible to unfavorable terms. For example, your company has developed a novel manufacturing process for producing eco-friendly packaging materials. With robust IP rights in place, such as patents protecting the manufacturing process, properly managed trade secrets, trademarks safeguarding the company's brand identity, your company has a strong bargaining position when negotiating with potential partners or with suppliers. Having secured its IP rights, your company can confidently approach negotiations with suppliers for example, raw materials or equipment. Suppliers recognize the value of your company's innovative manufacturing process, protected innovative manufacturing process. And they may be more willing to offer favorable terms or discounts to secure a partnership. Additionally, your company can leverage its IP rights as a bargaining chip when negotiating licensing agreements with other manufacturers, for example, who are interested in adopting its eco friendly technology. Options here are countless if you have properly secured strong IP rights. However, without proper IP protection, competitors can just learn about your manufacturing process and begin to replicate it without facing any legal repercussions. As a result, your company's unique selling proposition is diluted, its bargaining power diminishes in negotiations with both suppliers and potential partners. Is that what you really want? Without the ability to enforce IP rights, your company can find itself in a weakened negotiation position. Your suppliers may be less inclined to offer favorable terms, knowing that competitors can just easily replicate your company's technology. Potential partners may be less willing to enter into licensing agreements if they perceive your company's innovation as vulnerable to exploitation by others. That's not the scenario you envision for your company, is it? In other words, the point to remember is this: in order to truly safeguard your innovations and your creative pursuits, whatever it is, you must secure your intellectual property rights. How to do it? This depends on the type of IP rights you would like to secure. And following this mini course, you will get a pretty clear understanding of your options. This course is created based on the book Intellectual Property: The Key to Your Competitive Advantage and is recorded by its author, Maria Boicova-Wynants, in 2024. This was the first lecture of the lecture series Intellectual Property Strategy Without Legalese and in Under 100 Minutes. Thank you very much for listening and see you at the next episode.